Item number 1.
Number 1. I freshen up my. Yes.
Lordship, we have filed our objection, Lordship, to their.
Yes, ready? Start.
Yes, my lord.
Yes. Now, you've seen the objection, no?
Yes, my lord.
What do you have to see in the objection?
My lord, they have not come up with the actual objection to the application, but they have come in a general terms, my lord. That is my understanding with regard to the objection filed by the petitioner, my lord.
Miss Case. Miss Case. Miss Case. Yes, what is submissions on the application?
My lord, our miscase is simply praying, Lord, this honorable court to allow those project which has been given permission.
No, yes, here. Let's see your what's the
modification of order dated 9/4, my lord.
yes.
There is no specific amendment, my lord, to which part they want the modification of that order.
No, they have all this.
We have quoted, my lord, in page 4 and 5.
In sum and substance, my lord, they say that this order is an additional step, Lordship, to the subsisting
Which additional
rules.
step?
The formation of the committee, Lordship.
Yes. Oh yes, now remember.
Lordship.
Now whether this committee is necessary at all, would it be
Lordship,
odious
it is-
if it's an addition to provisions that statutory provisions already in place?
It is only to preserve the Lordship, the felling of trees, Lordship, because as on today, the Lordship, the situation in the state of Meghalaya, Lordship, considering all those aspects, Lordship, this order was passed, Lordship. Now it was passed in the month of April, Lordship. Now we are in the month of September, Lordship.
Yes.
And it is only an Lordship order which says that they have to take an approval from the competent authority, Lordship, and the competent authority is rightly, Lordship, looking into the applications and giving approval, Lordship. I don't think so there should be any impediment for them, Lordship, with the.
Yes, Mr. Arpay General.
Yes, I'm sorry, Lord. I was late, Lord. Lord, the issue is, Lord, that I have filed the application for modification of your Lordship's order.
Yes.
Lordship would recall, and I have already advanced the argument for that. I have placed, Lord, the statutory provision under which there is a committee set up under, and under that all permissions are granted, Lord. If I take your Lordship to the my application, Lord, which is kindly see my prayer, Lord, where my prayer is for modification of your Lordship's order, Lord, and that kindly see the application, Lord, is prayer, Lord, will Lordship will find at page
34, Lordship.
34. Modify the order dated 9th April 2025, passed by the Honorable Court to follow the statutory procedure laid down by for felling of trees in non-forest area. Lordship
Yes.
will kindly see your Lordship's order, my Lord, at page 37.
Yes.
Now, my Lord, Lordship will find the relevant part,
Yes.
that page 38, my Lord, on the scope of PIL was expanded because initially PIL filed by my friend was confined to his Khasi, particularly one colony, my Lord. On 5th March 2025, it was considered by us. We invited from the applicants a suitable explanation to the that a particular tree or group of trees needed to be felled as they had become dangerous to life and property. A state respondent were directed to inspect the trees covered by each and every pending application, process the application, take measures to preserve the tree or trees as far as possible, and only sanction that they are being felled had become so imminently dangerous that allowed to stand for every event sometime. They would cause damage to life, etc. My lord. Now, your lordship has taken note after that. Today, at the bottom of page 39, today report dated 9th April 2025 has been placed before us. On perusal of report, we find that officers of the rank of forest officer have been processing the application, and they have recommended large-scale felling of trees on the ground that their position was such that they pose a threat to life. Now, lordship, in direction, my lord, we also, second paragraph, 39, we also take judicial note of the fact that without any application, taking the law into their hand, many culprits are indiscriminately felling trees, then converting the trunk into logs, uploading them to transport vehicles, and doing commercial transactions with them large scale. Lordship is dealing with the illegal felling of the trees in this. In those circumstances, we pass the following direction. Unless a particular tree is imminently dangerous that it cannot be permitted to stand even for some time without causing danger to life and property, the local forest service shall not permit felling of any tree. None of the pending applications mention a report of 9th April 20 shall be processed further by ordering felling of trees. The Chief Secretary of State will constitute a committee. This is the part, my lord, which we are seeking modification. Committee of 3 officials in which the Chief Conservator of Forest should be first and expert in botany, whether in government service or private, should be second, and senior administrative officer not below the rank of third, who shall advise the government with regard to the steps to be taken to stop indiscriminate felling of trees throughout the state. Government will act in accordance with such advice. Scrutinize the above report filed before us, include the application to permit felling along with the report of local forest official, make their independent inquiry and issue necessary direction to the forest department to fell the trees or refrain from doing so, and take any measure for their preservation. Take district by district and deal with the application for felling of trees in those districts in accordance with passing suitable directions binding on the respondent local. We take note of the submission of Advocate General that Meghalaya Tree Preservation Act and Meghalaya Tree Preservation Rules apply to municipal and cantonment area of Ceylon, and rest of the state is covered by Forest Conservation Act 1980, read with Forest Conservation Rules 2003, any change in nomenclature thereof. On the submission of Learned Advocate General, we clarify that this order very necessarily does not cover any case where the central government has accorded permission for forest clearance under the Forest Conservation Act for any development purpose or any direction made in deforestation, afforestation, so and so. My lord, the lordship has excluded from the Forest Conservation Act. My lord. Now the lordship will kindly see that number of projects are there. And for which
No. Now, you just listen. Now, after this order 9-4 was passed, you didn't file for modification at that point of time. You carried out the directions as given by the court, in spite of you saying that
They followed lordship. In fact, they followed the direction.
Wait 1 second. Yes.
No, my lord, I'm coming, my lord. What my friend is saying, if your lordship will see, we filed for modification of the application the moment we came to know about the statutory provisions governing the entire process. Kindly see, my lord, standard operating procedure which we have annexed with this, because this could not be brought to the notice of the honorable court.
Exactly. What got brought notice here? Where's the SOP?
Yes, my lord. That is standard operating procedure. If your lordship will kindly come to the standard operating procedure at page 47.
This covers all situations.
It covers all situations, and it has been framed pursuant to the order passed by the Honorable Supreme Court, my lord, because this aspect is covered by the Honorable Supreme Court's order, my lord. On last date of hearing, I have placed that judgment also, my lord, but kindly see the SOP, my lord, which is framed in pursuance to the order of the Supreme Court, my lord, page 47, my lord.
Yes. What about forest land?
Forest land is covered under the Forest Conservation Act.
And then Tree Conservation Act covers its non-forest areas.
Forest land, and this is in respect of private areas, like in judicial complex in Bagmara, there is one tree fell standing which requires to be removed, my lord. For that, these are the procedures which have been laid down by the Honorable Supreme Court, pursuant to the order passed by Honorable Supreme Court, and Supreme Court has accepted these statutory provisions, and then only we follow those procedures, my lord. Therefore,
so your submission is that what is prescribed now, which is seeking to modify, is absolutely unnecessary and has created another layer of
yes, my lord.
contrary to the SOP. Supreme Court ruling.
Supreme Court ruling also, my lord.
Well, Supreme Court ruling.
My lord, kindly see.
Govinda Varman, where's that?
Govinda Varman, my lord. 2007, 15 SEC 283, my lord. Last time I placed that judgment before your lordship.
Whatever. Yes, yes. 438 or
2007, 15 SEC 283, my lord.
how come it's not with me?
Yes, if your lordship will see,
No.
and my statutory rules, my lord.
Meantime,
If your lordship will
comment.
kindly see statute.
1 second.
September 2.
Every judgment.
And there is a statutory rules, your lordship. Kindly see that the statutory rules itself refer to the
Judgment, judgment.
my lord.
A judgment.
Yes, my lord.
Report of an if I have take this report menu. I'm not coming this report, take it back. I don't need this. I don't need this. This report, they're all redundant. 2007.
Yes, my lord. 2007, 15 SEC
I got it. 283.
283, my lord.
Right. Okay, yes.
And your lordship will kindly come to your lordship will come to page second page, my lord, at 284. And paragraph 3, my lord.
Yes.
Failing of trees from forest shall be in accordance with the working plan schemes or failing schemes approved by the Ministry of Environment and Forest by this court order dated 15 June 1990. It is again clarified that such working plan schemes shall also be needed for felling of trees from any non-government forest areas, including land which are required to be treated as forest as
Yes.
the court order of 1212. While implementing the working schemes approved by central government, state government or authority concerned, as it shall ensure that no felling is done unless financial, etc. For felling of trees or non-fair areas in respect of plantation or non-fair, detailed guidelines rules shall be framed by the state government concerned, which shall also come into effect after same or concurred with modification, if any, by Ministry of Environment and Forest. Guidelines shall also include provisions for penalty, etc. My lord, and my guidelines are there, my lord. If you lordship will kindly see the guidelines in terms of this order. Guidelines is dated 3rd September 2007, my lord.
Where are the guidelines?
Yes, my lord, I have placed that guidelines, your lordship.
3rd September, this is yes, in pursuant to the direction contained para 3.
Yes, I am grateful, my lord.
Yes.
Para 3 of the order dated so-and-so, Honorable Supreme Court of India, so-and-so, with this so-and-so, dated so-and-so. Now, my lord, kindly see the procedure, detailed procedure approved in terms of the order of the Honorable Supreme Court, my lord, has been, each and every aspect has been taken care of, my lord. So, these are the statutory rules framed by the, framed pursuant to the order of the Honorable Supreme Court, my lord. And even for...
Yeah, Mr. Chanda, you didn't reply to these at all. Any objection? I've just seen that you're saying you're harping on the delay. That why it's passed in April, why they're coming now, why?
My lord, other aspect is that, my lord,
What other aspects?
they are saying that, my lord, they are being prevented from applying, and the projects are being delayed, my lord. There is nothing on record, my lord, to
Article
show.
141 wouldn't apply then. Then can this court go over and above for the prescription of the Honorable Supreme Court?
It is not in derogation, my lord. It is only in addition to the whatever is late, my lord. Considering the situation here, lordship, in the non-forest areas where, like, trees are being
But in this order sought to be, they have not this court not referred at all to para 3 or that in addition to the guidelines, like in other matters like that. Suppose for implementation of Supreme Court orders, then maybe this court can take up suo motu also if it sees that the guidelines or the directions issued are not being followed. Right, in the order,
and rightly, lordship,
a committee has been constituted.
And lordship, rightly from the month of April, lordship, they have been making, in terms of this order, lordship, they have been making application to the concerned department, and they are getting approval, lordship. There is nothing on record to show that till date, lordship, that
we can't go over and above what is the prescription of the Supreme Court, and the guide has been framed. The SOP is there, and also the Tree Conservation Act and Forest Conservation Rules. Okay, so this regime regarding forest management is very clear. So it depends not only on the implementing agencies as how do you go about it, how permissions are given, what is due process, what is not due process. That's the only thing. If they're not doing the job, you can hold them up. But the thing is that if regarding the structured regime is already in place, that's what this court is observing.
Lordship.
Yes. So anything over and above which you feel that yes, in spite of the
Existing
entire mechanism that's in
Lordship.
place, that is failing, then that is something which the court will look into as to whether the SOP, whether the rules, from para 3 of the judgment, when the Varman subsequent judgments was there, 24 I think, that whether it's being followed, and the response of failing the duty, that can be flagged. But I don't know what my brother says, but as per that's if a regime is already in place, putting over and above another layer, it becomes redundant in a way, and also it goes against the prescription of the order of the Supreme Court. Definitely.
Lordship, in that case, Lordship,
And the state government also happily constituted a committee also, as per direction of the court.
committee has been constituted. They are applying under the committee, Lordship. They have been getting the accepted, Lordship.
Problem.
No. But you did constitute a committee, right?
Because then thereafter, because what has happened, there are two wings, my lord, a forest department and administrative wing. So administrative wing was not aware of all these processes, my lord, the secretary level, etc.
Was it your duty to point out to the court and
Yes, my lord,
regard to that
it is my duty, my lord. I cannot sign, my lord. I should have placed that order, etc.
So everybody who's involved with this, see, since 1996 there was the ban. Maybe I can impute like a personal knowledge because we were doing all these forest matters. But after 96, the ban came, then 10 years, and after 10 years, 2007 came, then this, then when the ban was lifted, and these procedures were all in place. But I cannot imagine that that's not brought to notice of the court regarding working scheme, working plans.
Yes, Lordship is right, my lord. Because in TN government, time to time orders have been passed. In fact, my lord, recently also some orders have been passed because this matter is ongoing matter.
A central empowered committee used to sit for donkey's years that time by Supreme Court. I had personally appeared before them many occasions regarding working plans and schemes.
I have seen your lordship's order is recently in Meghalaya matter also was taken note, my lord. If your lordship see the other judgment which I have placed, 2024 judgment also, that 2024 3 SSC 438.
In fact, definition of forest also, they'll be happy that we had a role to play, with regard to.
In fact, my lord, a recent survey shows that, my lord, Meghalaya's forest cover is the least.
That has no meaning, Mr. Chanda.
Lordship.
What has happened in a forest survey? Sometimes the forest increases because even brush and undergrowth also in satellite imagery comes out as forest.
Lordship.
So you can't classify the forest also. It's like that. Yes? What paragraph?
Paragraph, my lord, 70, my lord. 70 of this 2024, your lordship has that judgment 2024.
Yes.
Yes, lordship will paragraph 70 and definition of forest in respect of, if your lordship will see the definition of forest in respect of each state has been noted, my lord.
Yes.
And Meghalaya is at the foot of the page, my lord, at
Yes.
page 472, my lord, definition of forest given under the rules of. So far as forest covered under this act, my lord, is covered under our Forest Conservation Act and rules, my lord. And for Forest Conservation Act, your lordship in that judgment also has, in that order also said that central government has cleared the permission under statutory rules.
What have you done about felling in unregistered private forest now? Is it permitted?
Because, my lord, this is also covered by statutory rules. If your lordship will kindly come to the statutory rules once again, there is a procedure for that also in statutory rules of 2007, my lord. Because everything is covered by that TN government judgment, your lord.
Yes, that's
if your lordship will see
that is
the guidelines, my lord, private also, my lord. If your lordship will kindly see the restriction of tree plantation also, a rule 3, my lord.
What do you propose to do?
Lordship,
Lordship,
what I am submitting is, Lordship, since it has fallen from your Lordship regarding the addition to the the committee being constituted in addition to the guidelines given by the Supreme Court. Lordship, to that extent, Lordship, I may be able to take instructions and then come back, Lordship, on the next day.
Chanda, we will just,
Lordship.
but we have to hold them to, we have to be responsible also.
Lordship.
So, the state respondents.
Because the moment there was, Lordship, what will happen again, Lordship?
Nothing will go because they have to follow the SOP.
Lordship, because again, Lordship, there will be rampant tree felling, Lordship, all around across the city, Lordship.
See, only thing is that they have to, their permission, what do you call it? How they grant permission, how they certify it, that's up to them. You understand? We can't have, from the court, we can't say, everything has to take the leave of the court from every tree being felled. That can't be the case.
Lordship may have it on the next date, Lordship. We'll take instruction on these aspects, Lordship, on these aspects regarding the addition of the thing, Lordship, and then Lordship can...
No, we'll pass orders. We'll pass orders, Mr. Chanda, yes.
Grateful, Lord, grateful.
Item number 2.
Yes, where's Mr. Deb?
Please, Lordship. Lordship will be filing the compilation in the course of the day.
See, what compilation do you find?
The pleadings, Your Lordship. Compilation of the pleadings
Is it ready with you now?
in the bar, Lordship.
Just have a copy of just a copy.
Lordship, its spiral binding is yet to be done, Your Lordship.
Can we just have a copy? Just have a look.
Lordship, spiral binding is yet to be done, Your Lordship.
See, in this matter, in the Miss case, orders all been passed by this bench, correct? What remains, Mr. Bama?
My Lordship, all the proofs have been given by me and none of the proofs have been rebutted by them as such.
What proofs are rebutted by them?
My Lordship, this court assailed by the orders by this court itself, like when we said that the consignments were brought from Assam, so we gave certain proofs. Against those proofs, this court ordered the state of Assam to file affidavits regarding GST invoices and all, my Lordship. Against those affidavits by state of Assam, we filed the rebuttals whereby everything was on record, my Lordship. None of the GST invoices which we have placed on record dates back since 2019 and today we are sitting in 2026. None of the GST invoices which have been placed by me on record have been refuted by the GST Assam department or any other department for that matter. And in fact, judicial inquiry, magisterial inquiry, police inquiry, all the inquiries have already been over. Since day one, we have been stating that the entire this PIL on the face of the PIL, this is nothing but a personal interest litigation which is being fought by Mr. Samuel Sangma, S. Sangma, and as such, the entire case record, the entire pleadings, they have only been shifting their stance on every footing we file an affidavit.
So you feel that the whole thing depends on the personal enmity between you and Mr. Samuel Sangma. Who's the name of the person?
My Lordship, Samuel Sangma. Yes,
Samuel
my Lordship.
Sangma. The
Yes,
whole thing stems from the enmity between you two.
Yes, my Lordship.
And you say the coal which you source from Assam is legitimate coal.
My Lordship, as far as the norms and customary practice which has been ongoing in Assam, the entire coal consignments which we brought from Assam, as per the rules and as per the trading which has been going on since ages in Guwahati.
What was the amount?
Pardon?
What was the total quantity of the coal?
My Lordship, the coal which we exported was around 2 to 3,000 metric tons, which
No, the coal that was in question, which
yes,
he said
50,
is questionable,
52,000.
as to where it comes from.
Yes, my Lordship, 52,000 metric ton, my Lordship.
That we could not explain the source.
My Lordship, the entire source which the coal wanted, when we said that we have bought it from open market, it is exactly same like if we procure a paddy from the market and if we want to know the exact source of the field, it is practically impossible to know the field. My Lordship, it's the biggest market in the Northeast and that's how it has been trading over there. My Lordship, authorities have been checking and there are number of checkposts which the trucks do come over there from the entire Northeast. It's not only from Meghalaya or from Arunachal or Nagaland that the coal has been being sourced in Beltala markets. And once the Assam government said that no coal was available in Assam, once they filed their affidavit back in 2023, by the way of RTI applications, we have brought to the notice of this honorable court that there were more than 300 racks, means the entire coal racks, which have been loaded during the same period in which we traded the coal. And on our
your
part,
submission, you maintain that whatever coal that was stocked in that Kwasupara area, or it's all legitimate coal, and that no one has invalidated.
yes, my lordship.
No authority has said that it's illegal.
Yes,
Only
my
on allegation of the
yes, my
petitioner
lordship.
that illegally, that's coal mined illegally from Karo Hills and dumped in
Yes, my lordship.
not Dandubi, Dudhna, whatever.
My lordship, Guwahati also. Like majority of the coal consignments which we bought to Gaswapada were from Guwahati, and once we traded those coals, the entire, because we knew that at some point of time there will be these allegations, these kind of allegations, because Mr. Samuel Sangma, he had been an instrumental in those illegal activities we have been complaining about to NGT since 2018 and 19. Those things are on record already, my lordship, in the entire PL.
So your coal now has already been auctioned?
My lordship, yes, my lordship, during the pendency of this PIL, the state have, although the Jimma application was still pending before the single bench, and while the criminal revision is still ongoing, the proceedings have not gone further because of this PIL pending before the divisional bench. The coal has been auctioned, and the manner in which the remaining amount of 16,000 metric ton of coal has been auctioned is really very concerning, my lord.
So now the thing is that 16,000 metric tons of coal is not there anymore. Now what remains in this PIL?
That's what I have been stating, my lordship, since day one. The only purpose which they want to achieve through this PIL is hamper our business, our legitimate business. My lordship, we have participated in the auction, we have not received the coal. We lifted the coal, we have not been allowed to sell that coal. My lordship, even our legitimate business, just because of certain misrepresentation from their side, from the petitioner side, we have been getting hampered day and again.
So your stand is that coal is legitimate coal?
Yes, my lordship.
It's been seized illegally?
Yes, my
It's already been auctioned?
Yes, my
Just
lordship.
on the allegations of the PIL petitioner?
No, my
as
lordship.
to other interests?
Yes, my lordship, I have already given on for proof. My lordship, none of their affidavits, if you may kindly observe, none of their affidavits, they are all evasive affidavits. None of the affidavit which they have filed is like to the point or reply to in our affidavit filed by us. All the affidavits have been evasive, and just the replies are evasive. And our affidavits are full in details, my lordship. And only thing they want to rely upon.
Refer to Justice Kataki, my lord, and the PIL can be disposed of, my lord. That all the issues, illegal coal mining, transportation is.
No, one thing, Mr. Advocate General, out here it goes beyond that. I think there's, from what we can gather, is that there's some. What compilation are you going to file?
Pleadings, Your Lordship.
My lordship, they have already filed like the last rejoinder which they filed on 26/5/2025. My lordship, they have already on the name of the evidence which they wanted to give to the court. There was nothing more than the orders, interim orders passed by this honorable court, and on those orders only they wanted to highlight that this court has observed that we are engaged into illegal activities. But in all the orders which they have filed and compiled in that affidavit dated 26/5/2025, it is clear that those observations were as per the claim of the petitioners. None of the interim. Yes, my lordship.
Because the thing is that your miscase already been disposed of also. Correct.
My lordship.
That miscase has gone. That your coal has been auctioned.
My lordship, that coal has been auctioned, but the manner in which.
Now, whatever then the other matter regarding Zimma, and you file a criminal petition also before the criminal bench.
Yes, my lordship.
What's the status?
My lordship, they are waiting for this PIL to be disposed of, because the order which was passed, the embargo through which the embargo was over this PIL, it stated that the coal should not be dealt without the leave of this honorable bench. But the same applied to the government also. Maybe because they auctioned that coal, But overall that is the same coal which was like part of this PIL, 16,000 metric ton of coal. And my lordship, all the invoices and everything, those are e-invoicing. I cannot backdate those things. Those are all on record since 2022. Those can be checked and verified through portals maintained by the GST departments.
Where's Mr. Vidya? He's here.
Yes, my lord.
Yes.
Lordship, this is a PIL. If your lordship will see this PIL, my lord.
Now, don't worry. I mean, don't look worried. It's all right. We just just trying to find out. Okay. Yes. We won't pass any order right now. We're just trying to get the the real ground situation now. Where can we go forward? Because if it's that case already been disposed of, and this situation, this is the where we are. There's no point in continuing with this. Anyway, when can you file it? What? This is filed by you.
No, my lord.
Yes. You've got a copy of this, correct? These are all true e-way bills of your company, Jaima.
Yes, my lordship.
So you file this one? File this one. There's no. You sure it's not filed by you?
Yes, my lordship, I have not filed this.
Just have a look.
Yes. No, my lordship. My lordship, I submitted in full 4 cartons the entire copy of
4 cartons is a different thing.
Yes.
But who made this compilation? By you?
This was, I think, their part of a RTI reply which they filed in 2023, my lordship.
Whose RTI reply?
They filed a RTI with the customs department, the petitioner, claiming that.
Where's Dr. Mozika? Now, where was this filed by customs department? Who filed it? There is no, what do you call it? Not forwarding, and there is no covering.
Your lordship will find the order of your lordship of 17th May 2023. 17th May 2023, my lord. Where in the second page there is a reference.
17 May 23.
Yes.
Okay, thank you.
Paragraph 6, your lordship.
1 second. Oh, this is. No, this is not. I'm talking about this compilation.
My lordship, if the affidavit filed by the petitioner dated 1st June 2023, they have filed affidavit along with this list.
1st June 23.
Yes, my lordship. That's my date.
You just return that to me. Bring that to the court.
There's affidavit. This report is a part of that affidavit, my lordship.
Part of?
That affidavit.
Dated? You're positive?
Yes, my lordship. It's 19th June 2023. They have filed it on 19th June 2023.
About 100 affidavits here.
List of dates. This one, I think. This one, you find this with the RTI statement. Look, this is the. Yes, my lordship. It's 19th March actually, my lordship. They have filed an affidavit on dated 19th March 2023.
19 March.
Yes, my lordship. Yeah, filed the RTL. This is the listener. This affidavit. Yes, this one. 9 months. Yes, that's. See,
19 March.
No, 9th March. 9th March. My lordship, 9th March.
218.
Dated, the date of affidavit is 9th March.
21, yes.
They have annexed this report with that.
Okay. Mark 3 series, but then it's not marked 3. This one. Anyway, you file that compilation by today. We will listed after 2 weeks. We will dispose of next date. Yes. When the matter is taken up today, MS Idahar, on behalf of the petitioner, again has reviewed a prayer for filing the compilation. So he submits that the same will be filed in the course of the day. Stop in interest of justice. The prayer is allowed. We list the matter. You take a fixed date after 2 weeks. We won't linger with the matter any longer. We'll just try
Item
to.
number 3.
3?
It's connected.
Three is also connected.
3 regarding what?
My lordship, it's regarding a auction call regarding which was purchased by Vaishno Devi Traders Private
Number
Limited. Yeah, my lordship. Just to confuse this code. It was the same code. Auction.
So this is regarding Weybridge. Then this should be good with the other matter. This is not regarding this is. You're not party here also, Mr. Ahmed.
Respondent 6.
Respondent 6.
Respondent number 6.
Oh, 6 yes. What's your role here? What's the prayer?
Made statements against us that we transported gold.
The trucks belong to us.
But
Trucks belong to you.
gold in there.
So we denied. We're not a transporter. We filed affidavit 6-9.
Which other PIL regarding Weybridge? Any that or
The petitioner name is Tenny Todd. I don't collect the
then why don't you list this together with that?
But the petitioner is also party, the respondent is also made party, and that is why if you also
Which
will
is-
see parties.
No, of course, but then if it concerns only regarding the management, regulation, operation of Weybridges, then why which is other?
Vaishno Devi Traders, if you also will see at page 14. And the allegation is this there, my lord, and there is a
Page 14?
Page 14 where you also will find memo party name of the 8 private party.
Yes.
Private party, 7 and 8. my lord. So 7 and 8.
No, what allegations against this Vaishno TV?
Yes, my lord. So
No, what? No. See one thing, Mr. Arvind, what is the meat of the matter here? It's regarding illegal transport or regulation of Weybridges.
Page 65 you also will see prayer. Page 65.
Then we'll take it together with this other matter. Yes.
Yes, you also will dispose of because this is a frivolous PIL again filed.
No. The thing is that if there's another PIL already, seized with the matter with regard to.
No purpose is served in having this PIL. Getting this PIL.
Police stack up police
Yes.
stack up
But there's no allegation against 7 and 8 here.
টুকি
there is some
লগাই দিব
allegation
কৈছে
against
Then we'll have it on the next day.
লগাই দিব কৈছে
Yes.
Yes, my lord. Paragraph 41 allegation.
List together with, so next day. Yes.
চাই ল'ব লাগিব হোৱাট ইজ about the article জানে নেকি গম নাপায় না 27 বুলি কৈ দিব পাৰে আদাৰৱাইজ 20
Item number 1.
May please, Your Lordship. I'm praying for some more time, Your Lordship, in this matter.
What happened with Siddiqui? Not well.
He is indisposed, Your Lordship.
Yes? After 2 weeks, then?
Yes.
It's connected matter.
Also is connected.
Item
I think you cannot disconnect it right now. Let it come together.
His Lordship. Much blessed
After
Lordship.
2 weeks. Tanno. Listen.
Any mention?
May please, Your Lordship, I beg to mention item 135, Your Lordship.
135.
Yes, Your Lordship. 135.
May please, Lordship. Lordship, I have some objections with this matter, Lordship.
Which one?
Lordship, this is with regards to the...
Cancellation of
Remnant
data. Yes, sir. Yes, Your Lordship.
Why put this?
Why objection,
about
Mr.
judge.
Harana?
135, sir. 135.
Why you have objections?
My apologies, Lordship.
135.
I have 134, Lordship. My apologies.
I have no objection, Your Lordship. No objection.
Have you? What is the verdict?
Your Lordship, we were still waiting for the judgment, Your Lordship. We don't
It
know
was not
which
pronounced
day.
that day
Not Your,
by the
no,
court.
Your Lordship.
Okay. We last this out 3 weeks in.
Next
3
day.
weeks.
Yes, Your Lordship.
Better yes. On a pre-MS just the matter after 3 weeks as the judgment of the trial court yet to be
Pronounced, Your Lordship.
Yes.
Apply.
Objected to by submission. I was wondering why objection was there.
May please, Lordship. Lordship, I beg to mention item number 132. So I've already informed the state respondents. Lordship. This matter can come after 2 weeks. Lordship.
2 weeks, yes.
Highly obliged.
Why? You come physically tomorrow. Tomorrow before lunch you can't finish it. Any bills with tomorrow let the petition.
We're here, Lordship.
With Dr. Mozika.
He's here.
No. Of course, I have to order. But the thing is that
Lordship, we have we are preparing the chart as well. It's taken
how
some
long
time.
will you take?
Lordship, we will be placing some more judgments.
How long will you take? Suppose just ballpark time. You can.
I think 45 to 1 hour.
1 hour.
1 hour. Lordship.
Then Advocate General 1 hour.
Lordship, in the meantime, we can prepare the chart as well because we're taking a lot of time because there's so many petitioners. We have started since Friday. It will take another 2 days time.
Because I on my own accord done something, and I from the judgment that Jagu also, I think apart from the West Bengal judgment, all of them appointed before Umar Devi.
Before 2000.
Yes, except for that.
Except for the Delhi
West Bengal judgment, and there's one judgment where they appointed after Umar Devi. But the rest where those directions came, they all pre-Umar Devi. So that also you have to address.
We have judgments today to that effect.
To counter those your Jagu judgment.
Not to fortify our judgments.
No, I'm just. Why
Lordship,
that you come, you'll be prudent exactly. What will be the because that's the only thing.
Lordship is correct.
Lordship, all the matters may be heard tomorrow, Lordship, but item number 3, 4, 5, 6, and 7 of the supplementary list have come up for the first time, Lordship, for motion. Pray that some interim orders.
One thing we'll do. When are you coming? We can't hear you. Tomorrow or day after? When can you finish your chart?
After 13, Lordship. 13 on Thursday, Lordship.
Thursday. On Thursday. Yes. SOP matters on Thursday. Yes.
Lordship, I pray that interim orders may pass in.
Don't worry until further orders.
Lordship,
they are fresh matters.
Fresh matters, Lordship.
Even my matter.
Let a matter be called out then.
Lordship.
Let me called out. Yes. Mr. Karan Lang's here.
Lordship, only in 124 and 125 extension because these are already. Because it was moved on Friday, Lordship. It requires extension. The interim. Item number 124 and 125.
No, but until further orders now. All the orders.
Lordship, because it's coming for the second time today, Lordship. So that order will not be done.
No, you meant, 121. None of orders, yes.
Obliged.
Yes.
May I please, Your Lordship? I beg to mention item 130, Your Lordship.
Yes.
130,
Who are
Your
assigned?
Lordship. I'm for the private respondent number 5, 6, and 7.
You are for whom?
And 8.
You have any objection?
No objection.
Okay, yes. 2 weeks. Yes, that's it.
Oh, pleasure. May I please, Your Lordship? Lordship, I beg to mention item number 133. I have already informed the other side, Your Lordship.
Yes.
May please, Lordship. Lordship, I have objections in
Lordship, the
Okay,
conducting
there are objections,
counsel.
so then we will take it up.
Lordship, the senior counsel, Sir K. Paul, is out of station due to some emergency, Your Lordship.
Mr. Hassan, there was Mr. Hassan. He's very competent. Yes, Hassan, you prepare the matter. We'll take up the hearing.
My lord, actually, the Mr. Kipol, he is handling the matter. My lord, he was engaged. My lord, he was due to some urgent matter in Supreme Court. He left Shillong on Saturday. My lord, kindly.
They have strong objection.
Last just
Lordship, objections have been.
My lord,
They've been seeking a general
So the Sheikh, yeah, objection also.
Lordship, yes, Lordship, because there is
Mr.
an interim order, Lordship, here. And
his
lasers are
inability
safari.
You prepare it, Mr. Hassan.
My lord, last chance, my lord. I am
You
just,
prepare it. We'll have it in the course already.
my lord.
They have objected. What can we do?
My lord, I understand, my lord. I'm just requesting
You
last.
prepare tomorrow. Or you do it.
My lord, last chance, my lord. Kindly.
Tomorrow, you, Mr. S.K. Hassan
My
briefed
lord,
some
please.
accommodation due to the unavailability of the senior arguing counsel. So however,
My
it
lord,
takes to argue the
my
matter
lord, kindly,
on
my
the
lord.
next date.
My lord, kindly on Monday, my lord. Next Monday, my lord. Kindly, I'll request Miss Senior to argue this matter, my lord. Kindly, my lord, on Monday, my lord.
So you consult with your friends.
Yes, my lord. I
But
request them
my
also.
lord, if the interim order may be lifted and we can take 1 month's time also, Your Lordship, I have no objection.
Okay. They have that. That's the counter proposal. The order is vacated, and we'll have it after 1 month.
My lord, on Monday, my lord, we'll argue, my lord. I request Senior to argue this matter, my lord. Kindly on Monday, my lord.
Very difficult.
Lordship, the people are suffering, Lordship, because they are 100 days,
My lord,
the daily wage laborers.
caretakers are taking care of the matter, the works, my lord. Due to some urgency, he left Shillong, my lord, on the Saturday evening, my lord. Which is why he cannot argue, my lord. Kindly on,
No, but
Monday,
they hardly do hearing matters.
my lord. My lord, surely bow down to that, my lord. I request kindly fix it on Monday, my lord, to argue the matter.
Okay, we'll have it on Wednesday then. Compromise.
My lord.
Yes.
My lord.
Wednesday, I'm not available. Thursday.
Okay, Thursday.
My lord. I'll deeply obliged.
Interim order may continue, Your Lordship.
Okay, interval to continue. 1:30.
133 and 134, my lord.
Okay. On Thursday. As 6 matters.
My lord, deeply obliged.
Understood. Next day, there we no further adjournment.
May I please, Your Lordship. Lordship, similar pair for item number 139.
Then we're left with nothing. 139 for objection.
Which item is this? 139.
Yes. Follow the list.
Objection.
Item number 1.
Yes, sir.
May I please, Your Lordship?
Yes.
Lordship, petitioner herein is before Your Lordship with regard to grant of family pension. And she is aggrieved by the impugned letter, that is, which is annexure 20 at page 92.
20.
Oh, sorry, Your Lordship. Page 21, 95, annexure 21.
Page?
The type copy is page 95, Your Lordship.
What is the H?
Your Lordship, may I read?
Yes.
Lordship, the petitioner was communicated with this letter, where is from the office of the respondent, that is Accountant General, where it seeks that in the absence of specific judgment and order from the Court of Law, this office is not in the position to issue.
What do you mean by in absence of any over?
Lordship.
We are saying a compromise.
Yes, Your Lordship. Here
You have compromised with the second wife.
Yes. And based on that, the deed
No,
of
but what's the matter
compromise.
pending before succession case pending anyway?
No, Your Lordship, that was granted in the favor of the petitioner.
And then you went and compromised with the respondent.
Yes.
Why?
The compromise was done before the succession was filed. And in the meantime, when the succession case
Then
was
how will
going
they
on,
resolve it then? Yes. No, but even then, where's the succession certificate?
succession certificate is as an annexure 4, that is page 57.
Annexure 4?
Annexure 5, page 57 is the succession certificate.
Then you already have in your favor. Why?
Yes, Your Lordship, we communicated with this succession to the commandant of the 4th Battalion, but no communication. Then after 3 months, we filed the RTI, where it's written that the communicated that the pension is already granted to the first wife.
So she's enjoying pension now.
Now she has waived her pension since last year, November 24,
After you
by compromise,
after
by executing
compromising.
the deed of compromise.
You made a party here.
Yes, respondent number 6.
You take this is a very funny case. Yes. Heard MS is in the counter petitioner issue notice. Mr. Benja is accepted on behalf of respondent 1, 2, and 3.
And 5,
1, 3, and 5. 1, 2, 3, and 5. MSE Pasa is present on behalf of respondent number 4. Notice issue to the respondent number 6. And this after 2 weeks for instructions affidavit.
Item number 2.
Lordship, this is a family pension matter, Lordship.
This is a family pension. What is the issue here? Yes?
May it please your lordship, the conducting council is in mediation. Kindly list the matter at the end of the board. It's in mediation, my lord.
In meditation?
Yes.
Mediation.
Mediation, my lord.
Oh.
I'll take instruction, Lordship.
Who's the conducting counsel?
Name Selvia Nongsi.
Yes, nonsense.
Anyway, what is your name?
My name, C.R. Marab.
C.R. Marag. Heard MS.C.R. Marag Vice is a legal aid matter.
It's about pension,
Legal
my
aid
lord.
matter. Vice MS.S. Namsi Legal Aid Council. Stop issue notice. Ms. S. Sheikh.
1, 2, 3, Lordship.
1, 2, 3. And you Pasal, except number 4. No further notice required on the respondents list after 2 weeks.
Much obliged, your lordship.
Must for instructions affidavit.
Item number 3.
May it please, Lordship. Lordship, item
Same
number,
matter?
same number.
What's the other items?
3, 4, 5, 6, and 7, Lordship.
3 orders, same orders. 3, 4, 5, 6, and 7. Yes.
Much obliged, Lordship.
Item number 8.
This matter had filed in September. However, due to technical objections, I had withdrawn with liberty to file afresh. Now I have come afresh, my lord. Your lordship's order.
Page?
My lord, page 163. This 22nd of September, my lord, I had withdrawn the petition with liberty to file afresh.
Yes.
So that was granted. My lord, this relates to the pension of the ex-MDCs, my lord, of the Garo Hills Autonomous District Council, my lord.
In association?
Yes, my lord.
Registered?
Registered, my lord. Your lordships will find the registration at page 44.
But yes.
So look, this pertains to
now this is but there are rules, right, governing pension.
There's an act, my lord. There's an act.
Where's the provision?
Yes, my lord.
This is council. Khasi also they have the same thing. This pension act, right, Mr. Shulai?
Lordship, yes.
They have. I think they have rules.
There was a judgment also.
They have
regarding-
rules, my lord.
No, regarding that, there was a. What about that Khasi's matter where they were granted pension?
May it please, Lordship. Lordship, let this matter come up end of the board, Your Lordship. As my senior is still on legs.
I'm just praying for notice, my lord. My lord, kindly have the act at page 70, next to 2.
There's an act in Garil.
Yes, my lord.
Lordship, at page 70.
70, annexed 2.
Where does it say the entitlement?
My lord, page 71, section 4.
When who has served 5 years?
Yes, 5
One
years.
term enough.
Yes, my lord.
With effect of this act, there should be paid a pension every person who served members of the council and whose term was not less than.
In fact, my lord, there was a previous round also, my lord, of litigation. Is it? Order of High Court.
Yes.
There was a previous round also.
What is the amount?
Lord, there's a chart, Lord, of the last.
Here, no, here says 5,000. Now it's still 5,000.
It differs, my lord. Those with more terms, the pension will be higher.
Anyway, we'll issue notice.
Yes.
But Mr. Fenua Nobody and Council Petitioner issue notice. MS Idahar present. Mr. N.D. Shulayan AG is present except on behalf of 1 and 2. Mr. MS E.B. Pasa for 3. Correspondence MS Idahar is present on behalf of 1, 4, 5 and 4 and 5. No further notice required. This after 3 weeks for instruction to have reviewed.
Deeply.
Item number 9.
May it please, Your Lordship.
Yes.
Your Lordship, this matter pertains to payment of salary, Your Lordship.
Salary. When were you appointed?
Pardon me, Your Lordship.
When were you appointed?
I was initially appointed in the year 1998, Your Lordship.
When did the salary stop?
21, Lordship.
21 has been paid till now.
From March 2021 till date, Your Lordship. There's a clear stipulation that in Annexure 2, Your Lordship, page 10, which states that even though I was placed in Tura Municipal Board from Bagmara Municipal Board, my pay would be continued to be drawn from Bagmara Municipal Board, Your Lordship. Ever since the date I have joined the Tura Municipal Board, I have not been receiving my salary, Your Lordship. Right from March 2021.
Annexure 3.
Annexure 2, Your Lordship. Page 10.
Before that, receiving salary?
Yes, Lordship.
You were posted in Bagmara only?
I was posted in Bagmara and then I was placed in Tura Municipal Board, Lordship.
Bagmara is a persistent problem. Anyway, I heard Mr. Lasonglia, the Council Petitioner issue notice.
I'm appearing on behalf of respondents 1 and 2, my lord.
MS Sham, on behalf of 1 and 2. Are you appearing for 3 and 4?
Yes.
You're accepting notice?
Definitely.
You're sure about that, correct? This is not this council. This is Bagmara Municipal Board and Tura Municipal Board. Yes, Amit Idahar accept notice on behalf of respondents 3 and 4. No further notice. Call for this after 2 weeks. For instructions are affidavit.
Bless you, Lordship.
Item number 10.
My lord, we are submitting a brief, my lord.
Very confusing the last time.
My lord,
you segregate East Castles and Riboy.
yes, I have segregated this.
Proper manner. Who are the claimants there? Who are the claimants in?
Yes,
Riboy?
yes, I have segregated, my lord. The first statement will allow us to withdraw to avoid confusion, my lord. But we have
We will disregard it. We will disregard.
Yes, yes.
Written notes of submission. Oh no, written. What's it called? What do we?
My lord, say the written notes and facts, my lord.
Here is written notes and facts. Oh no, written note and details.
In details.
Claimant has been filed by the senior council today. This is one only.
My lord, for Ripoy and East Castles.
In one compilation.
My lord, in 2 compilations, one each.
Page one.
My lord, I have given, my lord.
Yes, has been filed by the legislative council. So we'll post it for judge for we'll think.
My lord, item number 11, my lord. One of the writ petitioner passed away, so we have filed the substitution application, my lord.
Oh.
It is listed to them, my lord. Item number 11, miss case number 290, my lord.
This is in WPC number.
The WPC number 4775. 4775.
Okay, this case number 290/2025. in WC number 475/2024. Stop. An application for substituting the petitioner number 27 in the main writ petition who had expired on 18 June 2025 during the pendency of WC 475. Stop. This is a woman or a man?
The daughter, her daughter is replacing, madam.
So yes, the applicant's name shall duly be entered in place of respondent number, petition number 27. Yes, in the main petition, registry to make the necessary correction. In this case, stands allowed this.
Madam. In fact, my lord, may I just take lordship indulgence. I am sorry regarding my lord WPC number. Item number 12, my lord, WPC number 155. We made a mistakes annexing the award papers. Instead of annexing the award papers of these writ petitioners, we have annexed the award papers in the another writ petition.
That is what.
So we bring on record.
Very confusing. We're looking at it.
Five of them. So we bring on record through additional affidavit on records, madam. And the award paper may be annexed and the writ petition may be ignored.
That is the problem. That's why when I was looking at the papers, that's why I asked for those written facts.
Yes.
I was
Giving a judgment
lost.
clarified.
Because you see an lecture, so I don't know how to discern. If that isn't the East Khasiel matter, that means you put the Reboy matter, you put East Khasiel's matter and Reboy matter in the Reboy repetition, correct?
Yes. We have corrected the Reboy matter.
No, you made a mistake in the Reboy one, you put East Khasiel's one also. The same award statement. No. Correct?
No. That we did not annex, madam. We don't have annex
How
award
did
paper.
that? No.
Award paper brought by learned AG, madam. The only record, madam, undisputed is issued by the collector only.
It's a only legal issue, my lord. That's a
It's
legal
okay, even then, but the facts have to be, see,
We have
to be very frank with you, Mr. Advocate General, I'd already read the matter, I mean, the conclusions only in my mind, but I could not marshal the facts. This is not a point of law, so I could not, pull it together, where the facts.
But what we can do is, with learned AG, what I'll do, my lord, we'll give a separate award challenge with them, the final award. And that will be helpful for lots more. We will do that, madam.
We have clarified from our side.
Only
that affidavit, madam.
Okay, WC 155. Mr. H. Chanreso, WC 155. The Senate Council with Tidakhara submitted that due to inadvertence, the incorrect awards statement has been annexed. Award notice.
Award notices, madam.
Award notice.
Award notice.
Annexed. He praised the widow to bring on record the correct award notice by additional affidavit.
Well,
the same objected to by the other councils appearing. Seems allowed, yes. But and then add to it is further directed. Ms. Dr. N. Mozika as also a learned advocate general have volunteered to
informal paper book of the relevant annexes,
to be allowed to submit a found paper book containing the relevant annexes for approval of this court.
Two districts separately.
Praise allowed. Yes, for
We'll do that.
two separate districts. Praise allowed. Yes. That means we have to. When will you file it?
3 days time, but after tomorrow we'll file it.
Within 1 week, yes. List the last on Monday, then we said everything will be collated. Then we have to reserve it in open court. That's right. Yes. After 1 week. So hearing concluded. Pomcha together. List after 1 week.
17. 17.
Yes. Who was there?
The conducting counsel is appeared.
Who was the conducting counsel?
Miss Lamba.
Sir, am I audible to you?
Are you MS Lamba?
No, sir. Sir, I'm due to some technical issue. I can't hear you, sir. Hello.
Who's this?
Assistant.
Can you please make sure your technical issues are sorted out? We'll sit tomorrow. Yes. Due to technical disturbances from the petitioner's side, let this matter We list it again. Day after tomorrow is that. Give them 1 day's time.
18.
What's the matter about? You can move it otherwise?
Well, we have raised objection that they're coming to court for recruitment after 5 years, my lord. That's one ground, my lord. The second ground that they've withdrawn from Rajasthan High Court without seeking
Who's the
liberty.
local council who's briefed?
From Delhi, it's based.
Not from Delhi. I mean, local council with you here.
She's not here.
Miss Hongre.
You can't run matters this way. Unless the other council outside hands a brief to you and for you argue, and we won't. Later on, we become difficult for us to entertain cases. Yeah.
18.
Corrigendum is issued.
My lord, it is in process. It has not been issued, my lord. But it is going to take some time because it has to have the approval of the State Defence Minister, my lord. But they've initiated the process, my lord. If lots of grants us maybe a month's time, my lord.
With due respect, may I make my submission, my lords?
Of course, we are allowed to make submission.
Yes.
Yes.
My lord, on last occasion, I've sought time, my lord.
It was on 3rd of November.
My lord.
So we've given you 2 weeks time.
2 weeks time was given, my lord. Now they've initiated the process, my lord. It is going to take some time because it has to have the approval of the Defence Minister, my lord.
Defence Ministry or Defence Minister?
Defence Minister, my lord. In fact, Union Minister of State for Defence, my lord. What I would submit is simply a so-cause notice has been issued to them, my lord, and they can respond to that. They cannot blame any kind of bias on them, my lord. Once they submit their so-cause reply, they'll take a call, my lord. If there's no cases made out, definitely they'll drop the charges, my lord. If they are not able to issue a corrigendum at this in the meantime, my lord.
May I make a submission, my lords?
Yes.
My lords has already, as I have already put across my points now, my lords, there is one issue which has arisen now for the last 2 hearings is that there is a corrigendum which is being issued, and thereafter, my lords, the next step will be taken.
Yes.
What's the first thing which, in my respectful submission, is to be seen by the Honorable Court is whether this corrigendum can even be issued. Is there any rule? Is there any law which permits the department to issue a corrigendum which will change the nature of the charge sheet? One, my lords. But the rules, in my respectful submission, as I have done my research, do not permit that. The corrigendum at best can be permitted to rectify any typographical or clerical mistake.
On record is yet. That's the only problem.
But there is one corrigendum which has already been issued by them, which they have not even filed with their counter affidavit. After
Where is that?
May I just?
How do you get a copy of that? Issued to you?
Yes, my lords, already issued to me. A corrigendum is already issued to me, my lords, after I filed this writ petition. Before the counter affidavit, my lords, is filed. It's not even given to me, my lord. It's not even filed with the counter affidavit. Sir, I am giving a copy. My lords, this corrigendum is as per law. Because, my lords, may see the first page of this. It says for, there is, my lords, a highlighted portion of 22 to 46. In the second paragraph, this has been changed to 20 to 44. Corrigendum can only be issued for typographical and clerical errors, and my lords, this is also after my reply to the charge sheet is received by them. But the corrigendum by its very nature is for the purpose after seeing the reply, or if after issuing the charge sheet the authority is of the view that there is some typographical error, some document which had been left, name of some witness which was to be mentioned has been left, or some incorrect name has been mentioned, it is only for that. But from the very fact in the present case, the corrigendum which in my respectful submission is now sought to be issued, is going to change the complete nature. Now, the question which now arises...
No, one part. The thing is that first there was regarding delay and non-submission of the inquiry reports, correct?
Correct.
Now
it is
I'm sorry. Reports have been submitted.
It is always about delay, my lord. It is not about non-submission.
And now you want to correct your charge sheet to cut out the non-submission of the report part, or what do you want?
No, my lord. The purport of the charge sheet memorandum of charge is delay in submission, my lord. It is not non-submission. But somehow it is not very happily worded in that manner, my lord. And that is why they just want to issue a corrigendum to clarify that as well.
Why is it taking so long?
Only for that reason, my lord, because it has to have the approval of the...
submission is that this corrigendum of yours which you are contemplating,
my lord, It will not change. It will not change, my lord. Because in our affidavit, very clearly stated, my lord, the memorandum is premised on delay in submission of the inquiry reports, not for non-submission.
Well, I am not facing a counter affidavit. I am facing charge sheet. Charge sheet has only one charge, and that is non-submission of report. May I just say this, sir? I'm so sorry, the charge sheet does not say delay in submission of IO report. Charge sheet has only, my lords, one charge, which is non-submission of the IO report. It does not at any place say that there is a delay in submission. Muds, I can read that again for your lordships. I have read it 4 times. Muds, may I just take your lordships to page 72 of my writ petition, my lords?
You refresh the memory report of 72.
Page 72, my lords. That's the article. That's the charge, my lords.
Right.
The only charge. Admittedly, there is only one charge. Para 3, my lords. Page 72, your lordships has?
Yes.
It is statement of articles of charge framed against Sri Rakesh Chopra. Para 3, although Sri Rakesh Chopra, vide his 3 letters bearing number so and so, had confirmed that written brief of all the 3 DEs were submitted by the presenting officer so and so. However, Sri Rakesh Chopra has failed to submit the inquiry report even after repeated reminders issued to him by the CE Beacon from so and so to till date. Serial number so and so, despite multiple time extensions granted to him. Now, my lords, this is the corrigendum. Your lordship sees 22 to 46. Because, my lords, in my reply, I have taken a submission that you have mentioned serial number 22 to 46. There is no 45, 46. So, after reading my reply, they come up with a corrigendum saying it's 20 to 44. Now, my lords, the question which arises is, there is only one charge. You know, Mads, am I clear on that?
Yes, yes.
Mads, page 74 will further throw light on that. Page 74 is a further elaboration of that. The respondents can also take probably, Mads, this honorable court through page 74 to say that no, there are 2 charges. There is only one charge. Page 74, para 7. The above 3 DEs are part of the same composite. Has your lordships got that?
Yes, yes.
Arising out of a CBI inquiry wherein DEs under Rule 14 was recommended advised by the CBC against 11 graph officials. Out of the 11 DEs, 8 DEs have already been completed by the respective inquiring authorities and submitted to the disciplinary authorities for follow-up action, whereas 3 DEs are yet to be completed by Rakesh Chopra. This is, my lords, the statement of imputation.
Yes.
It is yet to be completed. My lords, in fact, the respondents in their counter affidavit has taken a categorical stand that I am misreading and manipulating the court by emphasizing on the word yet. But I can only read what is written, and I am in the hands of my lords, my lords, how it is to be interpreted. Yet? I'm sorry, my lords.
Yet they say delay. Talk about delay.
Are yet to be completed by Rakesh Chopra even after expiry of more than 2 years. So the charges, it is yet to be completed. Now, my lords, may I just, why is this corrigendum even being sought to be issued and why is the time being taken? My lords, the objective is single. The only objective is that an officer...
promotion.
Absolutely.
Okay.
But this is an officer who has been working for 30 plus years in this department. But I have a constitutional right to be considered for promotion. But here is a department, my lords. But on the face of it, but there is an order of this honorable court wherein it says it is not properly worded. But I need not go beyond that. But the honorable Supreme Court says if it is not specific, if it is vague, it has to go. But what the respondents, my lords, in my respectful submission are doing is, but the respondents want to change the rules of the game after the game has ended. And no, mods, it has ended. The charge sheet is already issued. Corrigendum is already issued. It is not a case of game is still going on. Mods, and in fact, what now they want to do is they want to issue a corrigendum after taking time from the honorable court, so that, mods, even if corrigendum is issued and I raise this question that this corrigendum could not have been issued as per law, the respondents can come to the court and say we took permission from the court. Mods, I have a categorical order from the Delhi High Court last year which says the petitioner is an officer of unimpeachable integrity. The respondents were at fault. They had taken an arbitrary decision. Despite that, in the counter affidavit, the respondents have taken a stand that I have done illegality and I am an officer of doubtful character.
Now see one thing,
even after that judgment.
Now,
Delhi High Court has not given any certificate of unimpeachable character, my lord.
Now, whether is a question of completion of inquiry or submission of the report.
I'm sorry, Manoj.
Is a question of completing the inquiry or submission of the report.
Manoj, the stand when I came to the court was whether this charge sheet per se could have been issued or not. And
now, whether their stand is that
they want to issue a corrigendum. So the whole nature of the case is being changed.
The letter sent by the petitioner.
I'm sorry, Manoj.
The letter sent by the petitioner to the department, whatever, show that he had already completed the conduct of the proceeding. Correct.
My reply to the charge sheet.
But yes, however, he failed to submit the inquiry reports. But he didn't submit inquiry reports. That's one of the charges.
Manoj, I can show from my reply that I have categorically said that the charges you are seeking to frame against me, the IO reports have already been submitted. Can I show that from my reply, Manoj?
No, it's okay.
Madam, may I cut it very short?
In fact, Manoj, I have also mentioned. I'm so sorry, sir. I
just one minute. I'm helping you only.
Please.
Well, what I propose, my lord, just to cut it short, my lord. Let them file a reply, my lord. Let the lordship give a direction to them to consider the reply that they have submitted charge sheet and pass appropriate order, my lord. That will solve the problem, my lord.
I'm sorry, Manoj. I didn't get what is coming from the senior lawyer, Manoj. I'm sorry. Reply to what?
No. What he's proposing is that you file the reply and categorically state there in your reply that you already submitted the.
I've already done so on 9th of May 2025.
Let them pass an order on that, my lord. Within a period of maybe 3 weeks.
Issue is very small, but just being made complicated.
The reason, the moment this direction is passed for consideration of reply, I will again have to come to the doors of the court. Something which has already been done. In April 25, I submitted my reply in May.
There are 3 replies.
I'll place
this as only one reply. I have submitted only one reply to the charge sheet. I had to come in August to this honorable court because despite my reply of May 2025 telling I have already submitted the IO reports, they did not take any action. But again, it is sought to be prolonged.
A time frame may be given, my lord, maybe 2
No,
weeks.
Manoj, I'm in the hands of Manoj. Manoj, I'm sorry, Manoj.
Why your lordship will interfere, my lord? I'll place 3 decisions, my lord. In what circumstances your lordship will interfere?
So one is correct. Okay, fine. This is a statement articles of charge. Yes, show cause against him. Correct. That is one part which is there. Now, why he's come here is that he is aggrieved with the charge sheet because it says the charge is based on unfounded materials. Because he's already submitted.
So, that's why I'm submitting.
Basis the foundation of the charge sheet is it's.
My lord, that's why I'm submitting. Let them give a reply to.
So whether the court can examine that now.
Lordship may fix a time frame of 2 weeks.
You have not disputed the fact that he has not submitted charge sheet. But now the question of delay. Now, if at all you can prosecute him or charge him with, it's a question of delay that he took nearly 2 years to complete the department inquiry.
But I'll tell why the respondents will not do that.
No, listen, that's the only thing. So if the charge sheet on a prima facie, you look at it, it does not support whatever is what are the facts surrounding the case.
My lord, that is why I'm submitting, my lord. Instead of your lordship conducting that exercise, my lord, let that exercise be conducted by the authorities, my lord. With a certain observation
with folded hands, let me say, my lords, why the respondents will not do that.
Lords, setting aside, then everything is over, my lord. But what I'm saying, that let the setting aside be done by the department itself.
No, my lords, I'm sorry. It has to be done by the honorable court. I'll tell why, my lords. The moment the ball is back into the court of the respondents, the only action will be issuing of a corrigendum on a charge sheet which does not have the approval of defense minister. That's the first thing, lords. This is going to be a corrigendum on a charge sheet in which there is no first stage advice of CVC taken. In fact, lords, on the last date, the honorable court had asked me a question whether in this case a CVC first stage advice is mandatory or not. My lords, I did a little bit of more homework. I have now, my lords, got a circular OM of the DOPT which is specifically issued for the IOs in the cases, my lords, where they acted as an inquiry officer and then the allegation is raised against them. Once the DOPT says for a IO to be questioned in a DE proceedings, there has to be a CVC first stage advice. But may I just show that, my lords, to the honorable court.
My lord, we are trying to dispose of the matter on preliminary issue, my lord. If they want a full-fledged hearing, my lord, let them file a rejoinder, let them come in hearing.
I don't need a rejoinder. May kindly have the CVC circular. But 2007 CVC circular. But this is a 2007 CBC circular, specifically criteria to be followed while examining the lapses of authorities exercising quasi-judicial powers in accordance with the criteria laid down by the Supreme Court. But may kindly have the next page, Manoj. But first paragraph will give the background. The Commission has therefore decided that the CVOs, while sending the case to the Commission for advice against the lapses of the officials exercising quasi-judicial powers, should examine critically whether any of the above criteria listed was attracted or not. In either case, Manoj, kindly mark, detailed justification should be given in arriving at the conclusion.
Well, this is 18-year-old, I have to find out whether he has been superseded.
I'm sorry,
It's not been modified.
Merge,
this is 18-year-old, Melody.
This is 18-year-old, and I have given Melody I have also already filed in the writ petition the CBC circular, which says wherever the integrity is challenged and wherever there is a delay, CBC advice has to be taken. 18 years does not mean, Melody, it is old. Melody, we have laws of 1886, Melody.
I have to check out from the department, Melody, whether this is superseded some new office.
What's my statement may be taken on record?
The statement will not do for quashing purpose.
Melody, may kindly have page number 199 of my writ, Melody. Page 199 minutes for a minute.
One second.
Please, Manoj.
Demanding, accepting gratification, obtaining valuable thing, obtaining for himself valuable things, possession of assets, disproportionate cases of appropriation, forgery or cheating.
Waiting, this one.
199.
This one is about it. Page 199.
There is no
I had drawn your lordship's attention to this on the last date.
If the vigilance angle is involved,
yes,
then it has to go to CBC. Correct.
It has to.
If vigilance angle
is not involved, my lord. In this case, there is no vigilance
let me
angle.
just-
It is only about delinquency to the extent that he failed to submit within the prescribed time limit.
But this is a 2004. The respondents say that this is to be read 2007, 3 years.
2012 is the other one that here office that OM exists
Yes.
also. Where regard if there's vigilance angle, then it has to go to
Yes, so I will prove that there is a vigilance
Where's
angle.
199? What do you want to show?
Whether there is a vigilance angle or not. This is the definition of vigilance angle. Page 199 your lordships has.
Yes.
What's vigilance angle definition of? What are those considerations in which there will be deemed vigilance angle? Your lordships may kindly have vigilance angle is obvious in the following acts. Has your lordships got that?
Yes, yes.
But it is about things regarding possession of assets. But this is mostly corrupted with corruption. But your lordships has para 2A, the last paragraph. There are, however, other irregularities where circumstances will have to be weighed carefully to take a view whether the officer's integrity is in doubt. Gross or willful negligence, recklessness in decision making, my lords. Blatant violations of systems and procedures, exercise of discretion in excess where no ostensible public interest is evident, failure to keep the controlling authority superiors informed in time. These are some of the irregularities where the disciplinary authority with the help of the CVO should carefully study the case and weigh in the circumstances to come to a conclusion. But in my case, integrity is questioned, my lords. Lords, may kindly have the next page, page number 200. Any undue, unjustified delay in the disposal of a case perceived after considering all the relevant factors would reinforce a conclusion as to the presence of a vigilance angle in a case. Your lordships may kindly have page 71 minutes. The charge sheet. Whether in my case there is a delay or not. Integrity and delay, my lords.
Yeah.
That's page 71.
We've seen that earlier.
2023 document given to me in April 2025, 4 days after I make a complaint against them. But there cannot be a much bigger proof of a malified action on the part of the respondents. Page 71, 2023 file. If your lordships for a moment just read this charge sheet as if it is issued in 2023, but it would make complete sense. Because in 2023, the IU report had not gone. Page 71, your lordship sees the first line, 2023.
Yes.
Mechanically issued on 22nd April, merely 4 days after I make a complaint in CP Gram Swaps. My 22nd April, my 18th April 2025 complaint is also on record. But the whole action is my lords, shrouded and my lords, clouded in the violation of the rules by virtue of which they have to be issued, my lords. None of the rules has been followed. And now, my lords, when the illegality has come before the honorable court, my lords, the respondents want that there should be no judicial finding on it. After my lords asking the court for, my lords, multiple times to, my lords, just issue a corrigendum for a charge sheet which cannot be issued. In the counter affidavit, they have admitted that we have not taken any CBC first stage advice. No preliminary examination is done. That's a categorical stand in their counter affidavit. Now, my lords, may I respectfully submit? Yes. This is a case where, my lords, I will demonstrate from the record that the charge sheet is issued to me not to punish me, my lords, just that. It is a series of victimization acts which are being done against me ever since I filed a whistleblower complaint, my lords. And that whistleblower complaint, prima facie, my lords, the findings are, yes, that there has been illegality done by the department. My complaint is correct. That's the prima facie finding. My lords, may I just show, my lords, how I am being victimized in the present case, my lords. My lords, may kindly have page number 84, annexure P4. This is a convening order of Court of Inquiry. Your Lordship sees the next page, 29th July 2022. The date is mentioned, my lords. The first step in victimizing me after March 2022 whistleblower complaint. But sees page 84, second last line, AR 180, Army Rules 180, para 4, second last line at the bottom. This is when the integrity of an officer is doubtful. That is when Army Rule 180 is invoked, my lords. This is the
Army
first.
Rule 180?
What's page 84?
What Army Rule 180?
Army Rule 180. This is, my lords, when the integrity of an officer is doubtful, because, my lords, me working in BRO, Army rules are applicable to me, my lords. This first court of inquiry is issued to me raising questions on my integrity. I am discharged. In this case, my lords.
Yes.
A second court of inquiry is done on the same set of allegations, page 86, in September 22. I am discharged from the first one, my lords. Second court of inquiry for the same set of allegations in September 22.
Page
86 and 87.
Convening order.
For the second court of inquiry, same set of allegations with a different committee. September 22, your lordships will have at page 87. September 22. Now, my lords, after this second court of inquiry is convened against me, page 91, my lords, I wrote to CBC. I am a whistleblower, please protect me. They are victimizing me. Page 91, CBC writes to the department that everything has to be kept in against the petitioner. My lords, as page 91.
Yes.
CUI ordered wide convening order dated 23rd September may be kept in abeyance till further orders. This is the CBC protecting me. The moment they send this charge sheet to CBC, they will never give, my lords, advice because they know I am a whistleblower complainant. But, my lords, they do not stop here. Even though, my lords, this is stated to be kept in abeyance, my lords, they refuse me the NOC to go on deputation. My lords, as an officer, as per the rules, I applied for deputation. I got selected in NHI DCL. They refused to give me NOC to go on deputation.
Without permission.
And, my lords, that I'm so thankful. My lords, the respondents mentioning without permission, the allegation against me was that I attended the interview without permission from the department. And, my lords, in the history of BRO, I am the first officer to face a court of inquiry for attending an interview without permission, whereas I named at least 7 officers who are on deputation despite not having permission, because the BRO as a department does not give permission to go on interview. They always say you first get selected, we'll give NOC. I was following that practice, but I had to challenge that refusal to give NOC. In the High Court, my lords would have page number 92 now. The counter affidavit is filed, wherein, my lords, in the counter affidavit, it is stated that petitioner is not mentally balanced.
Where?
He's a mental crook.
No, where is that?
Page 92 onwards will have the counter affidavit of the counter affidavit filed by the BRO in High Court Delhi.
Yes.
I am an officer of doubtful integrity. Page number, my lords, would find that at page number 108, 110, 120, 130, 136, 139, 147, 151. All these pages, my integrity is challenged. It is said I am mentally imbalanced because I attended the interview without permission. 8th May 2024.
Okay, yes.
Honorable High Court says your action was arbitrary and unjustified. And the court of inquiry which you are doing.
The entire charge sheet is founded on this premise. Why is not withdrawn and you hire liberty to issue a fresh charge sheet instead of going around getting corrigendum? And if it's a vigilance angle, then
in fact, that's what I advise them, my lord.
That's the only thing why we are. See, what we're doing is just like beating a dead horse here.
True, my lord. That's true.
Nothing will come out of this. Nothing will come out of this.
So, my lord, where I stand, like to be very fair to Lordship, my lord, even if Lordship sets it aside only on that ground, we will have liberty to issue fresh correction.
Yes, we'll pass orders.
But just one more thing your lordships will consider. Yes. One last thing. Even that will not sustain.
They have do one thing. You give your notes, notes on your submission by tomorrow.
But can I do it by day after tomorrow, my lord?
Day after tomorrow, yes. Then we'll pass orders.
And my lord, in fact, I placed 2 or 3 reasons, my lord, that when a memorandum of charge can be interpreted. My lord, that's why I was submitting, my lord. If lordship with certain observation,
we'll make observation, yes.
Ask them to file.
Give your notes on submission also. But the point issue is very short.
Ask them to submit a so-called, my lord, yes. And the department will take an action.
But can I give judgment on this, my lord?
Yes.
Whether the honorable court can interfere or not?
Because if this is the case, my lord, the disciplinary authority has to drop the charges, my lord.
Yes. If this is the case,
so instead of your lordship doing that, the disciplinary authority do that within a time frame.
Give a small submission by data tomorrow.
But should I submit my judgments with the notes or should I pass?
We are liberty.
Well, I'll do it with the notes itself, my lords.
Yes.
19.
Parties submit that we be permitted to submit the notes of submissions. This after tomorrow. This is very clear.
Well, that's what I'm proposing. Very shortcut, my lord. Within 10 days, 15 days.
Why linger with this thing? There's some big issue here, but nothing. It's like it's and in the affidavit itself, you said that it's not happily worded.
It's not said on affidavit, my lord, but that's what
is a sugar-coated word of not happily worded, my lords. It's actually not at all worded. Right. But item 19, my lords, is, my lords, on the ground that my annual appraisal for 22 and 23 has been spoiled and a below benchmark grading is given. My lords, I have...
Take it later. Have the file counter?
No, my lord. This is the third date, my lords.
Counter.
But I'll request it after 2 weeks, yes. If it is.
But 3 weeks. 3 weeks.
But I'm requesting.
Further 3 weeks time allowed. Expected next date that the affidavit be on board.
But I'll just
20. 20.
Oblige, my lords.
His Lordship. This petition is remained on the basis of the order dated 23/10/2025. The relevant portion of the order
restored.
Para 9 of this judgment.
For judgment?
Yes.
Division bench.
Division bench. Only on the limited issue on the inquiry report. This is reflected in the para 9 of the judgment. I have enclosed in my reply to the report, which I have filed it on 4th November 2025. That is on page 15.
So you take a copy to give him copy of the report.
Lordship, he has already taken.
What do you want to do?
That direction of this one, and we have filed a reply to that report also. It is
so what
now as per this order, para 9, only to the matter may be related to the limited to the report filed by the government. So that para 9 the judgment have stated there. Where Lordship,
if Lordship kindly come to para 9 at internal page 5.
Yes, in few paragraph 1.
Lordship, only the last 4 sentence, your Lordship, the writ petition.
Yes.
Down below, and writ petition are restored and to be heard afresh by the learned single judge confined to the finding against the appellant writ petitioner.
So it comes to this bench or it goes another bench?
Lordship, this is the bench which passed that order.
So
it will come before your Lordship.
Does not say the specifically it's come to this bench?
Yeah, it doesn't say.
You want to go another bench?
No, I'm not saying, but it does not say anything regarding the bench, my lord.
Have you filed affidavit?
I have filed, as per this order, I have filed within the fortnight that.
Where's the affidavit?
It is on record, Your Lordship. I filed on 4 November
What do you see in
2005. my lord.
affidavit?
In the affidavit, we are just a reply to the report filed by the this one. The report filed by the government on.
Oh, you just filed it.
Yes,
21/07/2023.
Yes. We are asked to file within fortnight, so I have filed it and comply as per the. So, Lordship, this matter can be listed for hearing. This is a detailed
What
hearing. This
hearing?
is for
We'll finish
order.
it now.
This is for order.
You
my
released the
lord.
matter today. Correct. Where's your? Yes.
Yeah,
Filed on?
File on
Okay,
November.
November. Yes, this one.
Yes.
Yes.
It is there.
Now, what do you see against the report? Show the paragraph.
Yes, yes, Lordship, I have make a detail. This one, Lordship, it is so from page 3. So I have make it para 1.
You seen this, Mr. Shulai? You want to file any counter this one?
Lordship, the
Very
report,
strict instructions, huh?
the report of the inquiry is very clear, Lordship. Only from the report of the inquiry, Lordship, I'll just.
Then when you want to have it?
After 2 weeks, my lord.
Yes, an affidavit in reply has been filed at petitioner as per the directions of the division bench passed in with appeal number 36/2025. As list the matter for
admission, Your Lordship. Notice will have to go, Your Lordship, to the private respondent. I think they are.
Notice go to private respondents also.
Before the divisions and the private respondent was not appearing.
Notice, already put notice, correct?
Yes.
The other private respondents who were already list after
Lordship didn't appear, Lordship.
This court notes that the private respondents who are parties before the division bench are not present today. The expected next date that they put in the appearance. That's number 4 only.
Lordship.
21.
Obliged.
21.
Connected, Your Lordship.
22.
Lordship, I have filed my rejoinder to the affidavit filed by respondent Bate.
Yes, party submit the pleas are complete.
Yes.
Only list the matter for hearing on so and so.
23.
Deeply obliged, Your Lordship.
I've already filed my rejoinder, Your Lordship, in this matter.
Here also pleas are complete.
Pleadings are complete.
Yes. When you want it for hearing? Next week? After?
2 weeks.
2 weeks, yes. Party submit pleadings are complete. List after for hearing, yes.
Obliged.
24.
May I,
This is complete.
5, 6, 8 and 9.
may I please, Your Lordship, in the course of the day, I will file the affidavit
On behalf of
respondent
5, 6.
8 and 9, Your Lordship.
What about 7?
7, it's read.
Already
Your Lordship.
filed. What's your name?
E Thaba.
Oh yes, you appeared last time. MSC Khaba submitted affidavit on behalf of the respondents number 5, 6, 8, 9. We filed the course of the day. This after 2 weeks for the joinder of any. Yes.
Must be associate.
25.
Lordship, I pray for 2 weeks' time, Lordship, to file our affidavit.
Where's the petitioner? None appears for a petitioner. This after 2 weeks.
Obliged.
26.
The respondent is yet to file their affidavit. my
Who's
lord.
appearing for respondent? Where's Ms. Karan Lang? Matter return of mediation.
Yes, my
Where's
lord.
the affidavit, Ms. Karan Lang?
Lordship, requires more time, Lordship, to file my
This is 2 weeks
affidavit.
for the time as prayed, huh?
This is the 6th time that I have.
Not for mediation. To give them one more opportunity. Yes, 2 weeks for the time as prayed.
27.
Affidavit. It's expected next year affidavit should be on board.
Much obliged.
Please, Lordship, this is on the basis of the order 29/10/2025. It can be this matter can be disposed of, Lordship, because
May
we
please
have already.
How much time will take?
End of the board, Your Lordship. Let
And
this
the board
matter
will
come
pay
up.
the gratuity.
No, Your Lordship. My seniors is on legs, Your Lordship.
After some time, we'll dispose it off.
Lordship.
Yes.
Much blessed, Lordship.
28.
Yes.
Wait, please, Your Lordship. I'm praying for
Where is
some
the
time.
affidavit?
I'm praying
It's a
for
fresh
some
matter.
time, Lordship. Yes, Lordship.
Fresh.
Not fresh, ma'am.
Not really fresh. Yes. Further 2 weeks time. Yes. Let's pray the Lord.
29.
May I please, Your Lordship. Lordship, we have already filed our affidavit.
Lordship, I will take some time to file my rejoinder because I have received their affidavit.
Mr. Please, I'm please funds allowed. 2 weeks time to file the joint affidavit filed by respondent 5 to 7.
Yes, Lordship.
5, 6, and 7.
Yes.
God bless you, Lordship.
30.
May it please, Your Lordship. Lordship, we pray for some more time, my Lord, to file our affidavit.
What's the matter about?
Implementation of EPF, Your Lordship. Implementation of Employment's Provident Fund.
What's the PPF?
EPF. EPF.
Why is the activist?
Yes, Your Lordship.
Employment Provident Fund. Yes, as stated further. You are praying for whom? For P. Barasaji?
Yes, Your Lord. For respondent number 6.
2 weeks further time as paid allowed to respondents to file their respective affidavits.
Much obliged, Lordship.
31.
My lords, I pray for 3 weeks time to file rejoinder. My lord.
Why?
On last occasion, we have sought liberty to seek instruction whether the
Yes.
so we will file
Now,
a rejoinder.
you are Mr.
T. Marngar.
Yes, Mr. So-and-so submits that praise are allowed to file the joinder. For 2 weeks time file the joinder, praise allowed. Yes, about 2 weeks.
32.
Lord, union is yet to file their affidavit, and as far as the state's affidavit is concerned, I'm praying for 2 weeks time to file a rejoinder, my lord.
See,
Your Lordship, in this case, last question I just read, Your Lordship. If I got the copy of the state affidavit.
You have not got it yet?
No.
You kindly give a copy. As if it's top secret, you're hiding it. Then? I don't understand. This is coming again and again every time. They're saying we're not getting copies. Pleadings should be. Then we have to have a date for discovery.
No, it's
Like,
on the last
after
occasion.
everything, they exchange the pleadings.
They have asked, they sought for
If they're not, then why you making complaint? Then we not ask for a copy.
They have not.
Your Lordship.
Why? They think will come and give it to you wrapped up in a like a present to your door. It's the duty of the council to look for it. Mr. S. and please allow 2 weeks time to file a joinder the affidavit filed by state respondents. Similarly, Mr. Devnath also. Mr. Devnath also prays for 2 weeks time to file affidavit. Yes. I'm not going to record. I think you take a copy.
33.
Please, Lordship. Lordship, I pray for some
What time is on?
My apologies.
No.
Pray for some more time to file my affidavit, Lordship.
But the date of it's already over, right? As per the
Sorry.
content.
It's already terminated.
Already terminated, Your Lordship.
Yes. Then
We're challenging the termination order, Your Lordship.
further 2 weeks time as it is allowed for affidavit. Yes, on soon.
I live, Lordship.
34.
Please, Lordship. Lordship, we are yet to receive the status report, my lord, on respondent number 6.
Number 6.
Yes, Lordship.
My lord, I'm praying for respondent number 1 to 5. My lord, I'm praying for some time to find my affidavit.
Mr. Ranja for respondent 1 to 5 to respond allowed for 2 weeks time to file. Affidavit was submitted by land council petitioner that the status report, the status of service on respondent 6 is yet to be received. Let's after 2 weeks for affidavit and for service report on respondent number 6.
Thank you very much.
35.
May it please your lordship. Lordship, we need some more time, your lordship. File the affidavit. 2 weeks time.
For 2 weeks time. Allowed.
Next item also same, your lordship. Apply.
37. Sorry, not connected. 37 connected.
Okay. This is matters on Thursday. Yes.
Hearing. Hundred 31.
Yeah, please, your lordship. This matter, my lord. The order have not been completed, your lordship. I think the order have not been completed. The order list is yet to be completed, your lordship, because we have item 26, 20, your lordship. Kindly have a look, your lordship. I think
Another board order will come.
Lordship, we have orders column up to 129, your lordship. Lordship, I think up to 125, these are SOP matters, your lordship.
Yes. Where is that 127?
Lordship,
you got any instructions? Who's for the
126, your lordship.
126, huh? 126. Yes.
We are in 126.
Where's 126? Yes, Mr. Sen.
Lordship, in this matter also we'll need some more time, your lordship.
This is the only thing, your lordships. This is a case, my lord, where my lord government has acknowledged my promotion is due from 2011. Now, my lord, only ground they have refused my promotion PhD. No, rule is very clear. PhD is required only for, my lord, those who entered afresh, my lord, after May 2010, when the rule was not.
Not the professor.
Yes. No, my lecturer. Polytechnic, it is only lecturer. Not for incumbents who are already in place. I entered service in 95, my lord, and I am retiring in February, my lord. Otherwise, normally I never insist, my lord. So unless then affidavit filed, my lord, the issue is adjudicating. What is the urgency, my lord? I am just conveying. February 20th, she is retiring, my lord. This is her hard-earned, my lord, promotion, my lord. On that ground, it cannot be refused, your lordships.
We'll file our affidavit, your lord. It'll be 2 weeks, your lordship. Within 2 weeks, we'll.
My lord, only thing ensure it comes, my lord. The vacation. I am fearing, my lord, the vacation is coming. Long vacation.
No fear, Mr. You can have when you're retiring.
February.
28th February.
Oh, it's a long time. It's a long time to
no, that vacation when
you vacation, you'll get retrospective promotion.
No. The law I have seen, my lord. Once I retire, my lord, only notional, not physical.
Notional, so you get financial benefit.
Financial benefit I will not get. No, my lord, that's the concern.
But this is a fresh matter.
Yes. Fresh matter.
Fresh matter.
No, I cannot help you. What happened? One item, they have taken a decision in 25 only.
Yes, further 2 weeks time is allowed to respond to an affidavit.
But the only thing they ensure, my lord, they file the affidavit.
We'll do it.
How come you can persuade Mr. Ashwalai?
Otherwise, my lord, you understand, my lord.
What will take it up?
127.
May it please your lordship. So far, item 127 is concerned, your lordship.
What instructions they received?
Lordship, I would like to raise the maintainability of
this. Maintainability, it is a case of pollution.
Lordship, kindly have.
Even if a person passing through some way also, if you know the danger, construction.
Lordship, kindly have paragraph 2 and 3, your lordship.
Yes.
The person that is Shimati Wheloris Anderson Soklet is not before your lordship.
It's not.
It's not before your lordship, your lordship.
No, we're not. You just say
lordship,
whether there's any.
PS, your lordship.
Only thing is that report. Yes. What do you have to say? Any construction going on?
Yes, my lord.
A lot of dust being created for children.
Yes, my lord. We need to do. My lord, inspection will take place.
No, the only thing, see, if there are children around and construction going on, notwithstanding.
It's true, Your Lordship. It's true,
Your Lordship. The final exam will be start from the 20. This month 20, Your Lordship. So in this noise, Your Lordship, how they will. I am not here for any injunction at all. Your Lordship, I am here just for giving instruction to stop the construction till the exam is going on. That's all, Your Lordship.
My lord, we can curb. We can curb. Well, all we can give is a direction, my lord. If a suggestion will be made, my lord.
The concern of this court is, in spite of question of mandatory being raised by the learned Additional Advocate General as to the locus of the petitioner in preferring instrument petition, the only concern of the court at this stage is with regard to whether there's any sound and dust pollution that's being caused in the construction site which is affecting school students in the vicinity. Top MSOI Bank Learned Council for number 3 submits that in this respect directions can be issued by Council 3 itself to curb the noise and dust pollution so as not to affect the students adversely.
St. Peter has.
Yes.
And my lord, a direction may be given that heavy machinery should not be used.
Should not.
That's up to you. You have to issue a thing. How whether not using heavy machinery?
They own lichen, Your Lordship.
What is heavy machinery?
Heavy machineries are, my lord, the
Sometimes small machineries make more sound than the big
Yes,
heavy
Your Lordship,
machinery.
heavy machinery tools are going on there, so that's why the sound.
Yes, you do it just after 2 weeks. Yes, apply a lot.
128. 128.
Number clear. No, this is the same matter SOP 128 also. You can read this together.
29.
Lordship, it's SOP.
This is all SP matters, yes. Thursday. Yes.
Second call. 27.
Yes. So how soon can you've taken instructions from your senior?
He's still on
How
legs.
long? How long?
He's still on legs,
You didn't
Your
go and
Lordship.
ask him for instructions. When can you?
He's
When
arguing,
can you
Your
complete
Lordship.
this process?
He's still arguing, Your Lordship.
He's still
Arguing
with whom?
in the court 3.
On the phone. We listen after 1 week. Yes. As the standing counsel, we will list after 1 week. Yes. Let's get you ask him how soon can you do it. We'll give a time frame.
Hearing.
What's your Lordship?
131.
May I please, Your Lordship? Lordship, this matters pertains to, my Lord, Fifth Pay Commission, my Lord, pay revision, my Lord. The petitioners herein are the.
Your Lordship has heard this matter, Your Lordship, regarding the employees of the MTC,
My Lord, partly
Meghalaya
heard, my
Transport
Lord. My only
Corporation.
one submission, my Lord, I would like to rely on their affidavit filed by the MTC as well as the state, my Lord. My Lord, kindly, the MTC filed by the state, my Lord, on para 17, my Lord. They are not denying, my Lord, to release the.
No. Can you compel them to adopt a resolution?
My Lord.
They have
Just
already
because
resolved
before.
to release the.
I remember.
Yes,
My
but
Lord
with
was-
effect from 2019 and not from
Yes, ma'am.
2017.
The as per the.
That
yes,
is
my
it,
Lord.
Your Lordship,
Only the
because
cut-off
the corporation.
What do you want to show?
My Lord, yes, my Lord. The affidavit filed by the MTC, my Lord.
Where is that?
Para 17, my Lord.
Okay. Para 17.
Para 17 of the affidavit filed by the MTC, my Lord.
That is that.
Yes, my Lord. May I read?
One number 2.
Yes, my Lord. Respondent number 2, my Lord. May I read, my Lord?
Where, which para, sorry?
Para 17, my Lord.
7?
Para 17, my Lord.
17.
Page 6, my Lord. Para 17.
Okay.
From the fourth line, my Lord, the state government, when sought information on the financial implication from the MTC, white letter bearing number so and so dated 9/5/2023,
Subsequently, the same was submitted to the state government white bearing number so and so dated 17/5/2023. However, a decision on the matter is still awaited, my lord. The MTC is not denying to release the benefit, my lord, release the arrears amount, my lord. The only subject to the clarification is to the state, my lord. The state supposed to release the fund, then MTC is ready to release the amount to the employers, my lord. Sorry, employees, my lord. The decision is still waited. My lord will recollect prior to 2-3 days, my lord. The government and the MTC was seeking some time to come back with the instruction on the regarding this issue, my lord. Since the issue is pending before the government, whether they will releasing the funds or not, my lord. So the issue is pending, my lord. And regarding the financial crunch, my lord, that cannot be the ground to release the benefit, my lord. But if the
now implemented from which date?
My lord, the implemented from 1/1/2019, my lord.
Now the state implemented 17.
State implemented from 17. 1/1/2017, my lord. They have passed a resolution in the year 2018 and 2022, whereby they have decided on the basis of the financial crunch, financial inability, and in the year 2020, they have also in the resolution they have adopted that subject to the availability of the fund from the state. The MTC.
Fine. Now the thing is that whether this court can issue mandamus directing them to implement the Fifth Pay Commission on an autonomous, on a corporation, which is not a department of the government.
Yes, my lord. It's an instrument.
From the date on which the state government, we can't do that.
My lord, only
they have independent decision-making powers also.
Yes, my lord. My lord, there is no doubt about it.
Long and short is that.
My lord, no, there is no doubt on that issue, my lord. The policy decision of the employer.
The policy, it's a decision of the board if they have a board.
Yes, my lord. But now whether the in absence of any rules by in the MTC, whether by a resolution they can change the cutoff date prior to the Fifth Pay Commission, my lord. The MTC has a history in the MTC. The fourth and third Pay Commission were implemented as per the government, the date of implementation, and the pay structures are also similar to the government, my lord.
Yes, granted, no quarrel with that.
Yes, my lord. But
so can we issue? That's only the question.
My lord, in case of discrete,
where a mandamus has been issued,
my lord, in
several circumstances.
My lord, in that case, my lord, I will not exactly similar, but slightly, my lord.
Slightly different.
My lord, slightly different. Slightly different. I would like to rely 2023 volume. I don't have the yes. Maharashtra. Yeah, slightly different. Yes, slightly different, my lord.
Yes, which paragraph?
My lord, yes, my lord. Para 2, my lord. Para 2 on the issue, my lord, regarding the. May I read, my lord? What is involved in this case is the fixation of date for the implementation of the Fifth Pay Commission recommendations when applied to the respondent corporation, that framing a policy concerning fixation of pay for the salaries to its employees, the extent of its revision, and even the date of its implementation are matters of undoubted exclusive executive decision-making powers. However, the manner of its implementation, the timing of applicability of a scheme, and its impact, especially where it results in exclusion of certain section of public employees from the benefit, are subject matters of scrutiny of the court.
Thing. If you talk about Article 14, it's a different thing.
Yes, ma'am.
Now can be like, you, A, B, C, D, they all work in a corporation, correct?
Well, yes.
Now they implement the Fifth Pay Commission.
Yes, my lord.
And the benefit only be given to A and B.
Yes, my lord.
Right.
Yes.
So then, in that case, B and C can come forward and say that, look, if we implemented like for E and D, what about B and C?
Yes, my lord.
Right. That's the thing. Then they'll come like then at least manner of implementation. You cannot discriminate if they work in the same corporation.
Same corporation.
In your case, nobody's been given.
But I agree to that point. My lord. I understand, my lord. The only, my lord, transport, the MTC is working under the transport, my lord.
No, we can't. Now we can't go there. Then that we can't. Go
My lord,
there
in
because
that
they have the independent decision making
my
power.
lord, now the question, my lord, they simply they passed a resolution on that in absence of any rules to the MTC, my lord. They passed a resolution and they changed the cutoff date on the issue of financial grants, my lord. Now, my lord, the decision is pending. The decision is pending before the government, my lord. Which they issued a letter, my lord. The government also filed an affidavit. In that affidavit, they stated that the matter with regard to the MTC is taken up before the government, and the issue is yet to decide, my lord. At least if
Now
they take a call for that, my
any
lord.
decisions come.
No, your
Any
lordship. They
category?
have decided that they'll go by the board's
Where's that?
resolution.
No,
That
they
is
have
not there, your
not come back with that.
You come
No,
with
the
a document,
affidavit
then
is
we,
there, your
then
lordship,
it's
where we have
over.
stated that the
No, my lord, the decision is
Game
still
over,
yet
Mr.
pending.
Hassan.
No, my
in
lord.
fact, your lordship,
Yes.
My lord,
can be
the decision
disposed
is
of,
still pending, my
lordship,
lord.
because they are not at par with the government employees. They cannot
No.
claim to be.
We understand that.
Yes,
The
your
thing is that
lordship.
it's a very basic issue.
My lord, yes, my lord. My lord,
It's a separate entity
my
altogether,
only-
your lordship. How can
my
they
only-
claim parity with the government employees?
Anything to say?
Yes, just 4 very basic points. Number one, MTC is not a party to this case. Similar situation as the Anamika Datta case, they've only made the managing director a party. I've raised this issue in my affidavit. They've not taken any steps.
MTC is not a party.
Not a party, only the managing
Then
director.
My lord,
How do managing director on his own give you your
Exactly.
my lord, MTC represented by managing director. my lord.
Kindly see page 8 of the writ petition.
Let's see.
The array of parties. I've taken a specific plea.
Oh, Mr. Hassan.
My lord,
Your lordship's
then on
already
that you feel.
rendered a judgment on this issue.
No, this is.
Yes. Yes.
Page 8. See the array of parties. One of the managing
director MTC, my lord.
Oh,
that's all. Only 2 parties.
Yes. Point number 1. Point
Number 2, my lords, the petition has been filed by 24 petitioners.
Yes.
The lead petitioner is Kharka Bahadur Thapa. He claims he's been authorized by the other 23. There is no authority letter.
But
No rejoinder again
But
filed
authorization
to
have annexed.
rectify.
Not authorized also.
No, not
No
authorized.
authority.
Authorization is
I have
still,
gone
my
through
lord.
it. Which authority letter?
My lord. It's all, my lord.
Where's that? Where's authorization?
My lord, yes, my lord. My lord, at page 49, my lord, in my writ petition. Page 49.
Okay.
Page 49.
Authorization is there. So, okay. Next point.
Page 49.
Next point.
My lord. The next point, my lord, as the writ petition stands, the challenge is to 2 resolutions taken by the MTC. One resolution passed in 2018.
Where's that?
Let's please see page 16. 1/6 of the writ petition, my lord. Your lordship, sorry.
1/6 is the prayer.
1/6 is the prayer, my lord.
Prayer.
In the prayer itself, my lords will find the challenge is to 2 resolutions.
Implementation to 2410.
24/10/2018 and 29/10/2020.
Yeah.
As we'll kindly see the first one. This is the resolution taken in the 151st board meeting at page 29.
Yes.
Now please turn to page 31. The relevant
31?
portion. Page 31.
2910.
29. No, it's 29 is the resolution. Page 31 is the discussion on this particular subject relating to this association.
Okay. Yes.
This is the agenda, fellows. Agenda number 9. Pay scale of MTC in accordance with the recommendation of 5th Pay Commission in 2017. The board perused the agenda item. It was informed that if the pay structure in the revised scale is to be adopted, there will be an additional monthly financial implication of an approximate amount of so-and-so over the existing salary requirement of so-and-so. Thus, for clearing an arrear of 24 months from 17 to 18, the financial implication comes to 5 crores. After due deliberation, the Board of Directors approved to adopt the 5th Pay Commission since the corporation is following the pay structure of the government. Therefore, it allowed implementation of the revised pay scale of the government of Meghalaya to the employees of the MTC with effect from January 2019 with a condition that its implementation is subject to availability of funds. So this itself points to the MTC's dire financial position. Then please see the next resolution which is under challenge at page 34. These are the minutes of the 154th meeting.
34, right. Okay.
Yes, my lord. Now here, before coming to the agenda, there is a discussion on the health of the corporation, the financial health. That is at page 35.
Yes.
At the bottom, my lords.
Every budget.
Yes, just this next paragraph. The managing director informed the board that the corporation is still having huge outstanding liabilities such as provident fund, leave encashment and gratuity, etc. With the serious efforts having been made by the management of the corporation to clear the outstanding provident fund dues in the last 2 years, the outstanding provident fund now stands at so and so. This amount is proposed to be cleared during the current years 2020-2021. Again, pointing to the MTC's financial health. Now, please turn to page 37.
Yes.
That's page 37. 154.9 is 0.09.
Yes.
The board deliberated on the matter at length, and it was pointed out by the member from the planning that as per the decision taken in the 151st meeting, ROP is to be implemented with effect from 1st January 2019. Then payment of arrear revised pay also should be made from 1/1/2019. Thereafter, it was resolved by the board that they should stick with the implementation of the 5th pay commission to the employees of the corporation with effect from 1st January 2019 as approved earlier. So the challenge is only to these two resolutions. Now, they are seeking to expand the scope of the writ petition by saying that since a question has been put with the government seeking financial assistance, the government should now be issued a mandamus. They have no relationship with the government, my lord. No legal relationship.
4th point.
And well, it's just one judgment on this point. So our case, my lords, is that the recommendations of the pay commission are not binding on us, not even binding on the state. My lords will see page 763, para 28. My lords have it.
Yes.
Para 28, placetum F.
Yes.
It is tried law. It is tried that the final recommendations of the pay commission were not ipso facto binding on the government, as the government had to accept and implement the recommendations of the pay commission consistent with its financial position. This is precisely what the government did. Such an action on the part of the government can neither be characterized as irrational nor as arbitrary so as to infringe Article 14 of the Constitution.
Yes, sir.
My lord, I would like to place on the 2003 judgment, with regard to the financial stability, my lord. That cannot be the ground, my lord. In case of, my lord,
in case of constitutional bodies,
my lord,
not in the case of corporations.
My lord,
if you're a constitutional authority, then you can't see fund.
My lord, corporations,
like GCDC, or they can't see.
My lord, corporations are also under Article 12. My lord. They are the instrumentalities of the state, my lord, because the state, my lord, are also liable to look after the financial health of the, my lord, instrumentalities, my lord.
Okay, you've tried enough,
my lord.
Yes. My lord. Take down. Well, counsel for the parties. The writ petitioners who are stated to be retired employees.
Yes, my lord, retired employees.
Retired employees of the Meghalaya Transport Corporation, an undertaking of the Government of Meghalaya, are before this court impugning, where is that? What's the page 17?
16.
Impugning
resolutions, my lord.
Yes, impugning 2 resolutions dated 24/10/2018 and 29/10/2020, passed by the Board of Directors of the Meghalaya Transport Corporation, whereby the 5th Pay Commission, Meghalaya 5th Pay Commission, has been adopted with effect from, what is that date, 19? Just kindly give the date.
My lord, 5th Pay Commission, my lord.
Yes, 5th Pay Commission for adoption with effect from
1/1/2019.
No, 17. No, from adopted by the resolution set from 9. Where's the date?
2019.
2019.
2019.
2019. 2019. So, the grievance basically centers around the fact that as far as the state government is concerned, the recommendations of the Fifth Pay Commission have been implemented since 1/1/2017. So, Ms. S.K. Hassan, a learned counsel for the petitioner, has argued that there is no rational basis to create the artificial date, inasmuch as in earlier occasions the date of adoption implementation is of the Pay Commission reports has been as per the dates which have been adopted by the state government. Stop. The council has further, what is for the argument?
My lord, the change of cut-off date is, my lord, arbitrary, my lord. The denial of the benefit is arbitrary and discriminate the petitioners, my lord.
The fixation of implementation date by the Meghalaya Tourist or Meghalaya Transport Corporation is arbitrary and has infringed Article 14 of the Constitution as far as the employees are concerned. Stop. He therefore prays that a manual be issued to direct the respondents to implement the Fifth Pay Commission with effect from 1/1/2017, and the petitioners be accordingly given their due arrears as permissible. MS Yangi Leonard EAG appearing on behalf of state respondents.
Number 1, Your Lordship.
State respondent. Number one. Respondent amongst state respondent. State respondent number 1 as the state government has submitted that what's the submission?
My submission is that, Your Lordship, the employees of the corporation are not at par with the state government employees, and that they are not entitled to.
Meghalaya Transport Corporation are not government employees, and they are subject to the directions of the board of directors as to their when what is the submission that
That they are not state government employees, Your Lordship, the employees of corporation.
and
They cannot claim parity with them, Your
and
Lordship.
cannot claim parity with regular government employees, and that the implementation of the Fifth Meghalaya Pay Commission is also a decision that has been arrived at by
The board of directors.
considering taking into consideration relevant factors such as financial constraints and so on. Stop. He further submits that though the matter had been brought to the government, however, as the decision rests with the board of directors, no further directions were given by the state respondents. So, next paragraph, Ms. SN, appearing for the respondent number 2, that is the managing director, has at the outset raised an objection that the relevant necessary party, that is the Meghalaya Transport Corporation, has not been arrayed as a party in the incident petition, and on this ground alone, and only the managing director of the said corporation has been made party. On this ground alone, he submits the petition deserves no consideration and should be dismissed in limine. Top. On other, he has also put counsel, however, has submitted that even on merits, the writ petition, even on merits, the no right has been infringed. No, even on merits, the writ petitioners have not made out any case, inasmuch as the decision to implement the fifth pay commission recommendations has been taken by a competent authority, that is the board of directors of the MTC. So, in this context, that council has drawn the attention of this court to the minutes of the 151st meeting of the board of directors held on 24th October 2018, wherein the pay scale of MTC employees, in accordance with the recommendations of the Meghalaya Fifth Pay Commission 2017, was discussed, and also to the minutes of the 154th meeting held on 29/10/2020, wherein the financial conditions of the corporation was also again discussed. As also discussed. Stop. He submits that based on these meetings, after a considered decision, the date for implementation of the fifth Meghalaya Commission was fixed as 1/1/2019. Further submits that the same being an executive decision, there is no cause for interference, and in support of his arguments has placed reliance on the case of the state of Punjab and others, wherein he submits the Supreme Court has held that the recommendations of the pay commission are not ipso facto binding on the government, as the same has to be accepted and implemented. In the instant case submits, the board of directors having taken a decision based on the financial considerations as to the viability of the date of implementation. No interference is called for, nor can a manifest issue in this regard. So, next paragraph. I've heard, on having heard learned counsels for the parties also, and on perusal of the materials as placed, the issue in question is only whether a manifest can issue to direct the respondent as to consider to implement the fifth pay recommendations in the circumstances pertaining to the instant case. Though the writ petitioner has not arrayed the Meghalaya Transport Corporation as a party, which indeed is a disabling feature which would normally entail dismissal of writ petition at the threshold itself. However, this court has also examined the other attendant facts and circumstances of the case. Stop. As submitted by the counsel for point 1 and 2, an undisputed fact is that the MTC is though government undertaking is a corporation with a duly constituted board of directors, and as such, on this and board of directors who manage the company independent of any government, independent of who manage the company independently. Stop. Though when company, before that, what sentence? Oh. Undisputed. It is an undisputed fact that with a duly constituted board of directors manage the company independently, and as such cannot be considered to be a department of the government Meghalaya or its employees, consider or it was taken to be government employees. Stop. Next paragraph. The decision with regard to the implementation of the Fifth Pay Commission from 1/1/2019, it is noticed by the court as is based on the minutes of meetings, minutes of 2 meetings of the board of directors of the Meghalaya Transport Corporation, which were held on 24 on 29 October and
24th October. Your Lordship.
sorry 24 October
And 29th October 2020.
and
29th October.
Stop. 29 October 2018. Next, stop. For the sake of convenience, from the minutes of the meeting, 151st meeting dated 24/10/2018, agenda 151.10, which is relevant, and agenda and from the 154th meeting dated 29/10/2020, agenda 154.05 and 15409, which are relevant, are reproduced here and below. So, a perusal of the above would clearly go to show that while arriving at the decision to implement the Fifth Pay Commission recommendations from 1/1/2019, the corporation had taken a considered decision, keeping in mind the financial constraints that the corporation was under. Further, it being settled law that the corporation, is the sole authority with the manner and date of implementation, and the same being executive being executive decision of the corporation itself, In the opinion of this court, no interference is called for. This paragraph. For the reasons aforementioned and on the facts circumstances of the case, the writ petition is devoid of merit and is accordingly dismissed. Yes.
136.
Hello, blessing.
This is the case, my lord. In fact, my lord, I have been insisting for a hearing in this case, my lord. In the meantime, my lord, I don't know, almost half a dozen adjournment, your lordships. Today, I don't know, my lord, learned senior counsel appearing for the respondent. He made a request, I don't know, my lord. He is not well.
Lordship, I'm praying for some accommodation, your lordship, in this.
Was he not well?
Not well, your lordship.
My lord, only thing, your lordship, my lord, is if it can be taken up on the next date, your lordship.
I'm not going to pass these orders. It's up to you how you deal with your.
My lord, I am always ready, your lordship. It's not that I am seeking adjournment, my lord.
Mr. Sen, we always hear.
What can I? My lord, I am always here, your lordship. Almost half a dozen adjournment. Let it come up next week, my lord.
After 1 week.
Lordship. Obligement.
137.
Please, Your Lordship. Lordship, as per the last order, my lord, of 8/8/2025, the state respondents were actually supposed to seek instruction, my lord.
8/8/25, what happened? Last time it came was 8/8/25.
8/8, my lord, yeah, thereafter.
Your Lordship, we were asked to find out how much was the total amount he had received and what is his monthly pension. So we've got these instructions, Your Lordship.
Yes. Does pension matter?
Yes, my
This
lord,
is,
pension
overdrawing.
and they're seeking to recover the, yes,
You give a copy to him, we'll have it next date.
Lordship.
Yes, as directed by pursuant to order dated 8/8/2025, the learned EAG has produced the a statement with regard to the amount of pension that we pay writ petitioner as per the last pay certificate. The same is taken on record. So this is matter after
which one? After a week, my lord.
After 1 week, yes. Copy of the statement be also be made over to the counsel of petitioner. You got a copy?
Yeah, I got a copy.
We'll examine it. Yeah.
Yes, my lord.
138.
Hello, bless, my lord.
138.
Please, Your Lordship, I'm praying for an adjournment as the conducting counsel is facing some network issues.
After 2 weeks, yes.
Thanks, Lordship.
In the prayer of the petitioner. Not them. How's your health, Mr. Abraham?
I'm okay.
You don't take morning walks anymore?
I do take still
During court hours or before court?
evening or sometime in the morning.
Okay.